Very good evening to all our participants here in Israel or in Europe. Good afternoon to our participants across the Atlantic. This is the fifth Corona webinar of the Minerva Center. I'm Eli Salzberger, the director of the Minerva Center for the Rule of Law under Extreme Conditions, and we had fascinating talks and discussions connected to the situation in which we are all in at the moment. And today we are going to discuss very, very important topics during emergencies, judicial review during emergencies, and it's a pleasure to have with us Professor Amnon Reichman, who is the principal investigator at the Minerva Center, and also recently became the director of the National Center for Cyber Law and Policy, which is also very relevant to our current crisis, all at the Faculty of Law, University of Haifa. Amnon will present for about 30 minutes and will open for a discussion, including the panelists of the Minerva Center and the general audience. And Amnon, the floor is yours.
Thank you very much, Eli. I think indeed this is a very important question that we're facing at the moment. And without further ado, I will move along because there's lots to cover. Very briefly, I wanna provide the framework for the examination of the Israeli case on the notion of judicial review. I will, again, because this question is very rich, I will not have time to compare the Israeli example now to other examples, but of course, I hope that during the Q&A we can also see that dimension as well. So. The framework to the question of judicial review under the current coronavirus crisis requires us to take a zoom out move first and understand some of the basic premises to the role of courts under emergencies. And we've heard from Gadi a little bit about this notion of uncertainty or managing uncertainty, but I'm going to look at it from a slightly different angle. So, and it connects to our previous work in the Minerva Center. This is, of course, something that we've been studying for quite some time. So I want to connect the dots. I want to connect our previous research to the current situation right now in Israel. So the basic premise with respect to the role of courts under emergencies requires us first to recognize, and this is something that, again, we've published on, and both Eli and myself have recognized, we have to first recognize the possible distinction between emergency and extreme condition. And that has to do with the notion of the rule of law. An extreme condition we propose to define as a situation whereby the law reaches its limit, and therefore the state is bound to face a dilemma whether to exercise power even without concrete enough legal basis, and that is on the basis of some kind of a prerogative that emerges in an extreme condition. An emergency is a situation that can be foreseen and therefore can be regulated a priori by shifting something, can be shifting a separation of powers, can be shifting other governmental powers, but it can be foreseen. What makes a situation, an emergency situation extreme is that it is either unforeseen or has not been foreseen, or the magnitude of the emergency is such that despite all the foreseeability, despite all the legal powers, you simply reach a situation where the state says, I need more. And then the limit of law are reached. And this is relevant to this current pandemic because everybody had in mind the possibility or the potential of a collapse of the medical system and other systems such as the economy. And if you reach a collapse, then you are in an extreme condition. Then the law itself may be less relevant, and then you act on the basis of necessity per se. So that's the first distinction we have to keep in mind. Of course, this reflects directly with respect to the role of courts in judicial review. The second premise is within emergencies. Let's say that we leave extreme conditions to the side and we talk about emergencies. Within emergencies, we know that usually under ordinary conditions, we are very keen on maintaining separation of powers. And by that we mean three types of separation: the functional separation, the non-functional separation between the judicial function, the legislative function, the executive function. We mean the territorial separation of power between the federal and the states, or between local and central government, which is key in any democracy, and the sectorial separation of powers. That is, that each agency has a sectorial responsibility, legal power to act within a certain sector or with respect to certain things, but they don't have, on purpose, they don't have a power to act across the board, because we want to achieve not only professionalization of each agency, but we want to retain some sort of a division of labor and division of power. Under emergencies, we need consolidation. The whole point of an emergency is that you need consolidation. That's number one. Number two, usually we prefer the measured approach, which is evidence-based, and until we have sufficient evidence, and until we have this evidentiary structure, we tell the state, please do not proceed until you're sure enough that you actually need to exercise your power. Under emergencies, we say we lower the standard, and this relates to what Gadi was talking about with respect to uncertainties. We lower the standard and we say, you just give us your best available guess. So we are operating on guesswork. It has to be grounded somehow, rationally grounded somehow, but nonetheless, these are scenarios that we call, that these are the scenarios that we ask the state to have in mind. But the scenarios are not sufficiently based in evidence. That's why we have some relationship to these scenarios. The worst case scenario, the most optimistic scenario, we don't know. So we act under a basic starting point is a lack of knowledge, and therefore it's a departure from ordinary governmental processes. And then last point we have identified in our previous research is that usually, in addition to separation of powers, we have this notion of checks. So this is not just balance. If the idea of separation of power can be understood as a notion of balance of powers, the notion of checks is that you provide a veto power or a checking power to certain processes. And the idea is that you want to protect against capture. Therefore, you insist, for example, on processes whereby before the state acts, and spends money, it has to have a public tender. It cannot choose just whomever it wants to work with in order to protect against capture and corruption. And the idea of course, rights is there to make sure that there's a check so that rights are not disproportionately infringed in the pursuit of the public interest. What happens under emergencies is, of course, you need a swift action. So all these notion of weight and checks are undermined on purpose, and the idea is that you need to protect the public interest, and the public interest is more urgent now. And then that leads to a sociological understanding that you move, at least in democracies or in liberal democracies, you move from an underlying justification whereby the state's role is to provide the necessary condition for individual flourishing. So the idea is that the individual is in the center, and the notion is that you flourish, you further develop yourself. The notion of the self is very central. And you move to the collective and the idea of defense, encircling the wagons. We talked about this, whereas under which the dominant framework is fear. So you move, the state there is to protect you against a great danger. With that in mind, let's talk about the notion of judicial review. So judicial review faces at least two types of tension. I'm going to focus on a rights-based tension, but there's another tension. Of course, the role of the judiciary is, the judiciary has two particular types of roles, generally speaking, and under emergencies. One is to protect the rule of law, and we talked about that. That is the idea that you do not act without a legal basis, a specific enough legal basis. The wording of the text has to be specific enough in order to provide the necessary legal basis for the state agency, the relevant state agency, to act. That's a rule of law concern that the judiciary is there to protect. And the second is that the judiciary is there to protect rights, individual rights or rights of minorities, that is group rights. And here you have a tension. You have a tension with respect to the rule of law that I mentioned before. Sometimes the law is thinly worded, and usually under ordinary times, the court would say, no, you don't have sufficient basis in law. It's not specific enough. It has to be, the words have to provide you with greater specificity. Whereas under emergencies, let alone extreme conditions, the court may say, okay, that's good enough. We just see that you have some basis in law. Go ahead and do that. And here the tension comes from, on the one hand, you want to make sure that you rein in the executive power, but on the other side, you want to make sure that you don't overly rein in the power because you need to exercise the power. So if the words are not specific enough, sometimes you don't have the privilege of re-legislating, going through the law in a careful manner, and providing a legal authority. With respect to rights, again, the tension is clear. As I said in the previous slide, the idea is that under extreme conditions and emergencies, the need to protect the public interest is greater. It's more acute, it's more urgent, and it comes at the expense of rights. On the other hand, so in that case, the courts should reconfigure the balance between rights and public interests. The court should allow greater margin of appreciation on some other similar margins for the state, whether it's the executive in its policymaking capacity or the executive in its enforcement capacity. The state should provide greater latitude for those who are acting on our behalf to defend us against this great risk. At the expense of rights, but at the same time, we know that it is especially under emergencies that the risk to rights is the greatest. And why is that? So very briefly, because I want to focus on the Israeli case, very briefly, we have three justifications for judicial review. One, we term the institutional bias review basis, and that is that the state, any state agency, when push comes to shove, will err on the side of protecting the public interest and under protecting the individual right. Why? Because if bad things end up happening, the responsibility will be on the public agency. People will say, but we have you there, you, the public agency there, to defend us, the collective, precisely for that reason. So why didn't you sacrifice the right you needed to sacrifice? So in cases of doubt, the agency will err on the side of the public interest rather than the right. So this is why we need courts. We need unelected courts that are not in charge. They don't have any policy-making role. They shouldn't have any policy-making role. Their only role in that respect is to make sure that the violation of the right or the infringement of the right was indeed really necessary. There was no other way. It was infringed, but using the least restrictive means. And there are other similar doctrines to achieve that purpose. The idea is that you have the court as a check to make sure that the state may protect the public interest, but it may do so only if there was no other alternative. And again, in emergencies, this clash is at its height, is at its peak, let's say. Why? Because the pressure to protect the public interest is at its peak. And therefore, it is easier for the state to err on the side of the public interest at the expense of the individual right. In other words, we will end up infringing rights more than we needed to, and this is why we need courts, number one. Number two is the equal protection rationale, and here the idea is that usually we can trust politics to protect groups, the distributive justice element of groups, but some groups end up with the short end of the stick because fewer groups will coalesce with them. There are some biases, they separate themselves or they are separated from the rest of the society, and therefore they require the protection of courts. This is the Eli justification or the Ely justification under democracy and distrust, why we need courts to correct the failures of the political market. And again, under emergencies, this is highly prevalent. Why? Because this notion of us and them kicks in. We allow the state to infringe our rights in the name of solidarity because we fear that the crisis will hurt us all. So we give the state, we empower the state to infringe our rights more than usually, more than we would otherwise allow. But this depends on solidarity again being there. But if there are some groups with which we do not really coalesce, and this is a coalesce not only politically but also sociologically, we see them as the other. The bond is not so strong with respect to them. So why will I be willing to sacrifice my rights in order to also protect them? Maybe they're part of the risk. And then you need courts to say, no, let's make sure that we're all in it together and the rights are equally protected. That's a second justification. And the third justification for judicial review is the Song of the Siren. And this justification is built on the famous Korematsu case in the US, whereby we all know, that's the heuristics or the bias that we have, we all know that we like rights, both liberty and equality, we like rights. But we also know that there will be times where the waves are going to be so strong, the song of the siren is going to be so strong in our ears that we will make irrational decisions over which we will regret later on. We will say we shouldn't have made this decision. Therefore, we need courts to tell us, slow down. Even though it's an emergency, even though you hear the song of the sirens, please slow down. Check your evidence. Make sure that you really can proceed. This is where the courts have failed under Korematsu, the famous US case whereby the state, the US said, we need to intern the Japanese citizens, the US citizens of Japanese origin, we need to intern them because there's a risk that they might side with the Japanese and provide some espionage or other services. They are a national security risk. And the court said, well, we trust your judgment. So the court was also under the influence, we trust your judgment, military authorities in the West Coast. So the court was under the bias of the Song of Siren as well. And we teach this case to say this is how courts should not behave under emergencies because they undermine the key justification for judicial review. But in any event, we should recognize the tension. So what do courts usually do? How do they manage the tension? Usually, they don't say we don't have the power to exercise judicial review. Certainly, they don't say that rights matter less. They cannot say that. That would undermine the judicial role. Neither can they say that rule of law matters less under emergencies. This is what the executive says, but courts never say that. What they do say is that they defer and defer. What do we mean by defer and defer? First, they defer to the judgments of the executive. And second, they defer in time. They say, we'll find mechanism to reach this decision later on in time. So this is the two types of deferrals. But occasionally they do assert their presence. They must assert their presence because if they're completely missing in action, AOL, then they undermine the institutional legitimacy of court. So occasionally you will find a case here, a case there, and to attract the attention of to signal to the public that they're still there and they're still available, but they really manage the institutional capital very cautiously. All this was just by way of an introduction to the Israeli case. So as we delve into the Israeli case, we have to recognize three starting points, three key starting points. The first is that Israel has been under a state of an emergency since its creation, and it's been a security-related emergency. At the beginning, and there's research about that, and I discovered this as well in my research, in the beginning, the claim is indeed founded that the courts really deferred in matter of national security. This is a statement that is usually stated with respect to the judges in Israel, and it's true for the first 30 or so years when issues of national emergency or national security came up before the courts deferred. But there was a routinization of the security risk, and at least during the early days of Oslo, the courts were willing to look closer at the security justification. And we have interesting cases whereby courts say, yes, security reasons, we hear you, but it doesn't mean full deferral. The law doesn't stop where security concerns are raised. So there is some erosion in Israel, at least at the national security front, with respect to the strengths of deferral that will, it's not no deferral at all, but the strengths of deferral has been somehow lowered when it comes to matters of security. There is also the Barak's court, the legacy of the Barak's court is the importance of the militant democracy. We see the notion that democracy, there are some fundamental principles, unwritten fundamental principles that any democracy should abide by, and the role of courts is to protect democracy. That's a lesson from the Second World War that Barak, that's actually the legacy of the Barak's approach to law. There are key principles that the judges are there in a democracy to protect, written or unwritten, and they should not veer away from protecting these principles, regardless of whether it's emergency or non-emergency. They should take, of course, account of the emergency as they do their balancing, but their key function is still very much there. And then I'm moving to the here and now. So these 2 points were historical points, and the here and now point is that we are now not just facing the coronavirus crisis. We are facing a triple crisis, which is the medical crisis. We're facing a triple crisis that is the interlace between the medical crisis, the economic crisis, and the constitutional crisis. So if we want to properly evaluate the function and role of courts under the coronavirus, we must be cognizant of the political situation. What is a constitutional and political background against which the court is asked to exercise its powers? And in Israel, it is clear that we are facing a constitutional crisis of significant magnitude, whereby the election process failed to achieve a resolution for 3 cycles. And then an interim government was serving as the crisis hit. And this is, I think, a key point. So to cut to the chase, the bottom line of my initial assessment, initial reflection is the court took a relatively strong position with respect to democracy debilitating threats. And I'll exemplify this with a couple of cases. Whereas with respect to ordinary rights, non-democratic rights, rights that in the court's mind are not directly related to democracy, the court veered the other way. The court gave over deference to the executive, to the state, even if we compare this to national security situations in the past. So very briefly, I'll now support my assessment with some evidence. The 2 cases, the 2 primary cases where we see the court really taking a strong position, almost unprecedented position during the emergency. One of them has to do with the election of the Speaker of the Knesset, that is the Edelstein case, and the other has to do with the surveillance cases. Very briefly, for our audiences abroad who are not directly familiar with these cases, the Speaker of the House of the Knesset, member of Knesset Edelstein, has refused to assemble the Knesset, the parliament, the Israeli parliament, in order to elect a new speaker. And the speaker based his decision on the text of the internal procedure rules of procedure of the Knesset, whereby the text says that the election should be held no later than the formation of the new government. So the speaker said, until the formation of the new government, I'm not under an obligation to call for elections. However, the Knesset has always functioned under a specific presumption that if 61 members of the Knesset ask the speaker to do something, the speaker has to have a very good reason why not to accede to the request of 61 members of the 120 members Knesset on the basis of just majority, the democratic majority governance. That is not to say that the 61 members of Knesset can do anything, but at least with respect to electing their own speaker right after elections, then there's a very strong claim that the speaker should abide by the direct request of 61 members and call for elections. But the speaker said, no, I'm not under obligation. And the court invoked a very rare doctrine in Israel whereby the court says there is deference to the Speaker of the House, or in fact to the Knesset as a whole, and the court will rarely intervene in internal procedures of the Knesset. However, to the extent that the court finds that there is an abuse of power that goes directly to the fabric of democratic fabric of the institution, the court will intervene. And I'm giving here the four reasons that the court provided. So the court view its role as protecting the Knesset against its speaker because of the request of the 61 members of Knesset. The court said, no, I'm not interfering necessarily in the Knesset proceeding. I'm interfering in the discretion of the Speaker of the House when he faces a direct request of 61 members. And there are three other reasons that go together with. So this is the number one is essential. It is a necessary condition, and it is also necessary that at least one, if not more than one, other reason will join that. So for the court to intervene. So this is the reason that the speaker gave was that I'm not calling for an election because I want to allow for the coalition discussions or negotiation to proceed unhindered. And the court said, that's fine, but that's now you're protecting the government and the idea of formation of government. You're not protecting the Knesset. The coalition agreements can continue. You have 61 members say that you need to call an election. The fact that you want to protect the conditions for future government, that's nice. It's not your role as the Speaker of the House, of the Knesset. The court was moved by the fact that there was no direct legitimacy of that particular Speaker of the House because he served as an interim Speaker of the House for 3 consecutive elections. So he did not necessarily have a direct vote of confidence from the Knesset for a couple of cycles prior to that. And then the court stressed the notion of the emergency situation. And again, very briefly, I want to point out to the other case, again, just to complete, the Speaker of the Knesset did not abide by this specific order given to him, and he resigned. Now, had he only resigned, we could have said, okay, you are the Speaker of the Knesset. If you do not think that the judicial decision is the correct judicial decision, you may resign. But the problem was that he did not, in resigning, he did not appoint an interim speaker. So by resigning, that meant that you had to wait 48 hours before the resignation actually took into effect. And then it was unclear how the Knesset should then go about electing a new speaker because these rules, the Knesset had a lacuna. There was no specific procedural bylaw to deal with this. So in fact, the court was requested by the counselor of the Knesset, the legal counsel of the Knesset, to issue a specific order to name a specific member of the parliament as speaker. And that's really, here we can say maybe the court overstepped its powers. Maybe it should have returned the issue to the Knesset and say, you figure it out, providing that, okay, the speaker resigned, you, the Knesset, figure out how to abide by the order that I issued. So there's debate about that. Of course, there's also debate whether the court should have intervened at all, because as it turns out, because of the intervention of the court, the blue and white party broke, was split, and then we now have, apparently, we're on the way towards what some call a unity government, others call it by other names, which includes also major constitutional amendments during an emergency to our basic laws. But that's a different topic, and I don't have time to get into that. I think personally that all those ex post facto assessment missed the point. The court's intervention should be assessed when it was given, and all the political aftermath I don't think is legally relevant. In fact, it's maybe even a benefit because the court exposed the underlying political conditions in the Knesset, and as long as there were 61 members petitioning the court, I think the court did the right thing, at least with respect to Edelstein 1, where the court issued the election of the speaker. Edelstein 2, as I said, where the court actually ordered who should be the Speaker of the House. That's a bit more problematic. The second case, again, very briefly, is the Adalah injunction cases, where the court had to review emergency regulation. This is a clear case of judicial review of the coronavirus measures. So the State of Israel empowered the General Security Services, the GSS, to use security measures, to use technical security measures and tools that it has within its powers to very potent surveillance tools that basically can track anybody in Israel using their cell phone data, and can also track all the history of their phone calls, and other data as well. So the government enabled the GSS, authorized the GSS to use these tools to track coronavirus people who are suspected of being sick in coronavirus, and then track down all those in proximity to those people, and then transfer the data to the Ministry of Health. And the court basically said, the court intervened by saying, this is really a major move. Why do you do it through emergency regulations? Why don't you get specific empowerment from the Knesset? We now have a Knesset, because the Knesset convened. There's a new speaker. A speaker was elected. The Knesset convened itself, or the speaker wasn't necessarily even elected, because the court solved that under Edelstein 2, and then the Knesset could convene its bodies and then proceed to supervise the authorities given, the legal authorities given to the General Security Service. Why do you need to have emergency regulations? Again, the court delayed its functions, delayed its intervention by giving the Knesset some time, but it issued an injunction. And then when it came to the Knesset was highly critical. The Knesset itself was highly critical of the General Security Service powers, and they are about to expire on the 30th of April, and that's quite a case to study later on with respect to judicial supervision of infringement of rights. But it's not necessarily the right of privacy, I think, that underlies, even if it's couched in those words. I think the court was more worried about the threat to democracy that underlies the empowerment of the General Security Services to track the civilians. There's a huge shadow here of less than democratic regimes that use such surveillance powers against their own citizens. I just want to mention very briefly that some cases that didn't even reach the courts, because the attorney generals or the counselors of the various state agencies intervene, and these are the demonstration cases. Demonstration is protected in Israel, even during emergencies, even during all those health-related emergencies. Very briefly, I will come now to the point where I argue that the court was. So these were two examples where the court was actually active, to use this term. Although I don't think that activist courts. I don't think the word activist or active versus passive makes any sense analytically, but just as a way of a shortcut. The court actually held a strong position protecting the rule of law and rights. And then there are several cases, 4 cases. I won't have time to get into details with respect to all of them, but there are 4 cases that show how the court actually was very differential. The first is a couple of cases with respect to senior home cases. This is geriatric establishments whereby elderly people were staying, state-owned places, and the state simply said, we need these places to have them ready or available for future corona patients, so please evacuate the place. We will find you some other solution, but those solutions were, according to the affidavits by the plaintiffs in 2 cases, were far from satisfactory. And in any event, the petitioner said, "Are you sure you need to throw us out now? We are the most fragile group in society. We need the state for our daily survival in those homes." These were geriatric patients they really needed support. They couldn't just be sent home. But the court said, no, there's not even a right here, but because you didn't demonstrate that you will, beyond a reasonable doubt. The court really set a high standard. You didn't show that it is most certain that you will suffer a great harm. And in any event, it is owned by the state, and we defer to the state judgment whether they will need it or not, even though the petitioner said that there are hundreds of empty hotel rooms in Israel. Why would you need necessarily to throw us out? So that's one case where the court was deferral. The second where the court was deferral was a Bedouin case. Again, very briefly, whereby Bedouins said, please distribute more tests, more coronavirus tests to the Bedouin communities in the Negev. You only have three mobile stations available there with some kits. But if you look proportionally, we need more, and it's more difficult for us as we're scattered around the desert to reach the designated mobile stations. And the court basically had no patience for that. The court said, it's just some difficulties in mobility. I don't see any right here. There's no right here, and we just have to defer to the state. And again, I can go into greater details if you want. In the Bnei Brak closure case, again, the court was highly differential. And the Bnei Brak petition is interesting because Bnei Brak was saying, first of all, you don't need to close the entire Bnei Brak, and we see this also happening in other cases now. You can be more proportionate in the way you proceed. And also, what do you mean when you closure us? What type of medical assistance will you give those in Bnei Brak? So the state says we'll remove you and isolate or quarantine you outside, those who are suspected. But of course, the people said, well, what do you mean? The people will leave their own families and go out to be isolated outside? It doesn't make sense sociologically. It doesn't take the right to family life seriously. But the court was highly differential and said, well, we're not going to interfere here. And the right to pray case is the last case I want to mention again briefly. So religious people said, well, it doesn't make sense if you can demonstrate. If you maintain 2 meters or 6 feet, slightly more than 6 feet apart, you can demonstrate de facto without any limit, although the regulations are weird. They say you need to have 10 people, clusters of 10 people, 6 feet apart, but the distance between each cluster is unclear, and basically it means that as long as you maintain 2 feet apart, 6 feet apart, 2 meters apart, you can demonstrate, and we have demonstration of 2,000 people. So the religious people said, we will abide by the same rules, just allow us to pray. And the court said, no, we cannot, we're not going to interfere. So there's an odd legal rule now in Israel that if you congregate 6 feet apart for a demonstration, that's fine. But if you pray during this demonstration, that you violated the emergency rules, and then you will be fined rather heavily. So that's, again, an odd decision by the court. So what the legal techniques the court used? First of all, the court said there's no right here, as in the senior home cases or the Bedouin case, or that the court deferred on matters of evidence and least restrictive means. We see this in the Bnei Brak case clearly, and we see this also in the senior home cases where the court said, well, even if there was a right, we don't know whether what the worst case scenario or realistic scenario is. We defer to the government. But the most important thing for my purposes here is to show the failure of the court to distinguish between the public interest and the right. A key function in the operational logic of judicial review, and with this I will almost conclude, is the notion that
Amnon, we want to have some discussion, so
okay. So I will conclude. Yes, I will conclude with this. The key distinction is that the court is there not to balance between equal rights, whereby you basically defer and you say, okay, well, if the court says there is a public interest. You, the state, you are allowed to infringe a right in order to protect the private interest, but we need to see that you have no other alternative. When the medical crisis was transformed into a right to life of everybody rather than the public interest, then you do horizontal balancing, and in horizontal balancing, individual liberties always lose. And we see this clearly in the cases that I mentioned. I don't have time to get into areas where the court does assert. I said sometimes courts are differential, but they do assert their presence. And so there are two examples here where courts actually assert their presence. If we have time under the Q&A, I can say something about it. And I want to leave the room for the floor for discussion, and to tie it back to the constitutional crisis. Now there are pending cases back to the constitutional crisis with respect to the power of a person, or the authority, the legal authority, to take into the consideration whether a person, a member of Knesset charged with bribery, with serious offenses, can be a prime minister, whether the president must or can take this into consideration. This is now under review, as are other matters of the coalition agreements under review. So this circles back to democracy, and I conclude my lecture. Thank you very much.
Thank you very much, Amnon, for this fantastic, comprehensive, and deep lecture about judicial review in times of emergency, the case of Israel. As you were speaking, actually, the Israeli Supreme Court, sitting as a High Court of Justice, gave a final decision in the case of the electronic surveillance by the GSS, the General Secret Service, and actually accepted the applications for judicial review. It just held that the power of the General Secret Service will expire on the 30th of April unless the Knesset will enact a law accordingly. So this is a very interesting development, just connected to your talk.
The Cosmos is designed. They knew we were having this webinar now, so they made it relevant exactly during the conversation.
Right. I'll make three short remarks with regard to the three sections of your lecture, the theoretical one, the historical one, and the contemporary one. I'll make it very short in order to allow others to comment as well. And those who are interested, please either raise your hand or send a message in the chat. So with regard to the theoretical background of why do we need judicial review in times of emergency, you really emphasized the balancing between the public interest and the individual right, which becomes different in times of emergency, in times of acute emergency. But I think that there is one stage before that, one has to, there is a need for judicial review in order to find out that the regulation, that the policy, that the decision by the authorities was for the sake of a public interest and not for the sake of private interest, political interest, more power. And of course, this is the primary need for judicial review, even before the balance between public interest and individual rights. You characterize the second remark, you characterize the history of Israeli judicial review in times of emergency as the feral and the feral. And I slightly beg to differ. I think that from the very beginning of the state, the court intervened, especially if we talk about comparative perspective, if we compare our court to English courts, from which we inherited our tradition, or American courts or European courts. So even in the early years of the state of Israel, and some of the important decisions, annulling confiscation of property for security reasons for all kinds of officials, and other decisions were quite brave and intervene in times of emergency. I think you are right that most of the formative years were mainly procedural intervention, or intervention on the background of lack of right procedure that was taken by the government. And from the 80s, we are talking about a more intensive or substantive interference. But I think that, might be kind of a correction in the characterization of the history of judicial review in Israel. Last comment with regard to today, it's too early. We are only 6 weeks into this crisis. First of all, I have an impression that the court procedurally really hears, decides, discuss very, very quickly. It's amazing how many petitions were launched and how many petitions were already decided or heard or interim decisions. So you see actually the presence of the court now in a much more intensive scale than before, and this is quite interesting. And a second point is that I think you are right that many petitions in which there is a clash between the public interest and human rights are rejected or dismissed. And here I think that there is a call for further research. There is kind of different benches, different judges who sit in different cases. It's very early to say anything about this. This has to be really examined more empirically. But there are the judges who dismiss appeals because they don't want to get into this balance between the public interest. Other judges are not. And you see for the constitutional issues, you see different benches than from administrative issues. And it will be interesting in retrospect to really examine to what degree the personal ideology of the judges really mattered and whether, the onslaught on the Supreme Court by appointing conservative or more conservative or super conservative judges actually yield results in terms of individual judicial decision making.
Thank you, Eli. Very briefly, just very brief comments because I want to open up the floor for everybody else. I totally agree with you that I was slightly imprecise in my presentation. You are absolutely correct that the first role of judicial review is to smoke out illicit purposes, that under the guise of emergencies, some power grabs are conducted. So the court has to make sure that indeed there is a rational connection and there's no apparent illicit motive underlying the state use of power. And I take this, you're absolutely right. With respect to the history of the courts, and again, I beg to differ. I think that the only case I could find where the court was brave and indeed only on procedural grounds is the famous El Khabutli case from 1949. But in all other cases, the court never, in the first 30 years, I'm not aware of cases where the court went directly against the national security interest, where the state said we need this for it. A clear case is Ikrit and Biram, where the state acted in an almost unconscionable way. There was a promise, and then the court backed this promise, and then the state said, oh, but there's national security reasons we can't allow these people to return to their villages. And the court said, oh, if there's a national interest, if there's national security interest, then we defer. We don't look further into that. So I think you're right that there were some procedural interventions, maybe one or two, but the overall picture is a picture of deferral. Even in the 80s or 70s and early 80s, before Barak joined the court. So Barak joined around 78, but there are still cases whereby the security establishment completely disregards the law. In the case of the Kawasme case, where deportation cases, the security establishment disregarded the law, and the court said, it's very bad that you disregard the law. One judge said, well, we have to take into consideration the necessity of the security, and this is why we have the necessity defense in the security context. And others said, even if we don't take the necessity, we will give an after the fact right of hearing, which basically says, it's procedural, but it's not substantive. It doesn't treat it. With respect to access to court, I totally agree with you that it's comparatively speaking, it's really, really important to highlight that in Israel, access to the Supreme Court, direct Supreme Court, where you have a petition. Some petitions are weird petitions. So there was a petition to the court that the Jewish calendar should be amended to include the 13th month in order for people to be able to celebrate Pesach after the Corona. And the court said, are you sure that I can give you this type of remedy? But still, the court was there for this petition. So I think you're absolutely right. With respect to the empirical point, the last point of the empirical, I agree that we need to wait and see. However, my initial impression that some key progressive judges, such as Fogelman, that otherwise you will find in siding with the petitioners in matters of right, here in the corona context, recall their past history, their own personal history as part of the state establishment. I don't know, but you see the difference. But you're right, we should wait and see and have more cases than maybe conduct an empirical study. We do see, on the other hand, fewer judges, recently appointed judges, siding with petitioners, but again, the N is too small, and we can't. Sometimes they use harsher words. For example, Justice Alex Stein, when he rejects the petitions, he makes it a point to say, you were so wrong. Why do you even bother us? Something like that, and then it's there are lines there. Then it makes you kind of feel, maybe it has to do with this judicial approach more broadly, but we have to wait and see.
Thank you, Amnon. Any of the panelists, Minerva panelists, want to comment, ask a question? Itamar, Gadi, Shelley?
Sure. So thanks very much, Amnon. I'm sorry. I'm not on mute. Yeah. It's fascinating. Two very brief kind of questions, maybe comments. One, I agree with your argument that not infrequently the judges may identify issues of fundamental issues of human rights and become counter-majoritarian. It's obviously mainly within the Green Line. It's not about the 1967 occupied territories. And by the way, it happened also in the 50s. I mean, Kol Ha'am is one good example. And already in the 50s, the court made some salient, notwithstanding relatively few court decisions. And one explanation which may foster your research is actually the Bruce Ackerman argument of constitutional moments that actually might be in judicial history. The judges would identify an historical opportunity and will make a point, often regarding fundamental issues of human rights. So this is my first comment. Second comment, however, notwithstanding, it almost doesn't happen in issues of national security, let alone regarding the 1967 occupied territories. So there is a research done by, and supposed to be published in a few months, by Rosenthal, myself, and Meidani, and we show that the probability of an appeal regarding national security is 3 times less to be upheld than, let's say, an appeal regarding state and religion. This is my second comment. My third comment and last one is about COVID-19. it seems to me that the judges don't conceptualize COVID-19 to be an issue of national security. They identify it to be an issue of human security. And I think that this is an important distinction, because once it's about national security and you have the military coming into the picture and you have the Palestinian issue, the court becomes relatively very conservative. Even the liberal justices are becoming very conservative. But the COVID-19, it's a bit different. So here we have, as we talked last week, a severe issue of uncertainty, but the court doesn't feel as much intimidated by the potential reaction. Now I'm talking about pure issue of COVID-19. I'm not talking about the appeal regarding the coalition agreement and Netanyahu. It's a different issue. So I think that once it's only COVID-19, they would feel a bit more flexible regarding a probability to uphold an appeal. But thanks, it was a great lecture.
Amnon, you are muted.
Thank you. I just unmuted myself. I think, Gadi, I will still have to think more about your point about constitutional moments. I think we are in a constitutional moment right now when it comes to amending the constitution under stress that is within an emergency. The rationale for amending the basic laws is if we have to have an emergency government, and now we are amending the basic laws in order to allow for an emergency government and including, there's a coalition agreement that says that there will be no legislation that are unrelated to Corona for 6 months. So you change the function of the parliament, you restrict the function of the parliament. So it would not to legislate for a period of time on matters that are not related to COVID-19. So it is a constitutional moment, and we still have to absorb what it means. I don't think we fully realize the extent of the potential shift in the structure of governance that we are now facing. With respect to your two other points, whether it's human security or national security, I think I would tend to agree with you, but interestingly, the court, the evidence doesn't support yet the fact that the court is willing to intervene more in COVID-19 cases than in national security cases. And again, the very partial list that I have here demonstrates that the only intervention that we find is the unpaid sick leave case, whereby the chair of the relevant medical council in Israel is technically the doctor of all those who were sent for an unpaid medical leave, because technically the law says that a doctor has to say that you're sick. But they're not sick. They were sent to a medical leave not because they're sick, but because of the coronavirus. But their doctor said that they should be sent to an unpaid leave. So there's a procedural deficiency here, and the court honed in on that, which is clear that it goes along with what Eli said before. When there's such egregious procedural violations, the court will intervene. And I think the court is also quite sensitive to the economic dimension here. I think. I don't have any prophecy powers, but I think there will be several petitions. There are already petitions before the court with respect to the economic dimensions of what the state has done. And I foresee that the court will have to face its own legacy, how it dealt with social and economic rights in the past, and decide and hear what Eli said before, whether you have conservative judges or more progressive judges. It will make a very big difference to what extent the court will not directly with COVID-19, but with the recovery stage, at the recovery stage of the COVID-19, more with respect to social and economic rights, to what extent the court will demand that the government will have a stronger evidentiary basis, will act more proportionally, etc. That remains to be seen. And lastly, national security versus state and religion, that again, that it veers slightly off topic with respect to the COVID-19. It makes sense what you said, that the security establishment will enjoy a higher degree of deference than state and religious questions. However, I think that I would be worried, again, the uniqueness of the Israeli case here is interesting because it's a counter-Illy's point. In Israel, you don't have a discrete and insular minority that is discriminated against in state and religious, other than, of course, the Christians and the Muslims. They are discriminated against usually as a discrete and insular minority, but it's rare that the court actually assists them, as we see in the Passover cases where, you know, they wanted to get an exemption from Passover laws and the court didn't find this convincing. But when it has to do with state and religion, ultra-Orthodox Jews, then there's an inverse issue where there's a rent-seeking component of tie-breaking parties. And therefore, I think that there is an inverse Illy justification to say why you need judicial review, and there's literature on that, so we can talk more about that. But thank you for the comments. I think they're very helpful when I sit down to write this as a paper.
Thank you, Gadi. Thank you, Amnon. Any Itamar? Deborah?
Just a couple of thoughts, and one of them has to do with Gadi's comments, you know, about COVID-19 being seen as human instead of a security threat, and I think that might be somewhat weakened because of the decision-making constellation now. I mean, our FEMA was basically disappeared before COVID-19 occurred, and so it really is a lot of the security branches that are acting in it. So I'm wondering how that will affect your hypothesis. I mean, what was another question that Ellie actually already brought up, so I don't have to do it, is the you know, the implementation of judicial review and determining public versus private interest. I think that will be very interesting. And then a little bit off, but there was an article today in the New York Times about complacency and not panic being the real danger. And they were quoting Ido Erev from the Technion, who was giving examples of why this is the case. And his, basically his conclusion was that because of the complacency which will inevitably take place with COVID-19, as opposed to panic, that you really do need steady enforcement and small penalties. And I'm wondering how that's actually going to work itself out. You know, he was talking about how that's been effective and other things like among workers at manufacturing plants or something like that. But I don't know.
No, this is an excellent, two excellent points. One with respect to the lack of FEMA and the securitization of the crisis, and we talked during our wonderful panel earlier this afternoon with Itamar. We talked about the securitization and who is one of us and who is not one of us when the states have to assert their powers, immigrants or non-immigrants. That was quite a fascinating discussion. I think that we see the securitization, just to give you an example of a current research proposal we're considering to launch. There is evidence that the state body in charge of providing advice for the government, the Council for National Security, Moatza Lebiטachon Laumi, the Council for National Security, which took over our FEMA because of the collapse of our FEMA. Not only did they securitize the whole framework, but they immediately turned to the experts they know, and the experts they know are military experts, including or physicians from the Weizmann Institute that, you know, they're
or physicists.
Physicists, sorry, not physicians, physicists from also some are also physicians, but mainly physicists, you're right. For reasons I won't go into, there are reasons for that. and they were asked to consider how to react to a possible civil disobedience threat in Israel. So our intelligence officers working within the military were asked to participate in discussions on with respect to constructing a campaign that will affect our consciousness and identity and ways of thinking in order to counter the threat of potential civil disobedience, which is a clear example of securitization. You know, that's something to consider.
Right. Whereas complacency becomes civil, you know, becomes a security issue.
That's right. That's precisely the case. That's precisely the case. And that it goes with the General Security Service beginning to track us. Even though we trust the General Security Service, they're good people, generally speaking, at least when it comes to those they view on the right side of things. And, you know, they view generally citizens of the state of Israel who are part of the Zionist majority as on the right side of things. So why fear them? But again, this is the secularization when we are perceived as a potential enemy, that undermines a lot of the structure. And that ties to the second point you made with respect to steady enforcement with little fines. I think there's this is a classic talk about constitutional moment. This is a classic time to conduct a research or conduct study about our failure to turn to trust and ADR types of resolving disputes rather than more adversarial enforcement techniques used by the state in order to enforce the measures. I'll just give an example. So there's a famous case whereby a woman was arrested for buying books. Now, books are not considered essential products under the emergency regulation. So had she bought medicine, it would have been okay, but because she bought books, she violated the emergency regulation. So she ended up she ended up being arrested because she was scared and she didn't comply with the request of the police to stop. So she got, you know, she was under pressure, she left, and then she ended up being arrested. Now you could, you know, an alternative way to deal with that would say that the cops could have said, you know, this is not what you're supposed to do. Next time you need books, come to us. We'll buy you the books if you need. We're here to protect you. We're together in this. We're not here to catch you and catch your violations. We're here together. So if you really feel you need books during this quarantine, just let us know and we'll provide. Either the police or the municipality, doesn't matter. We see an example.
And transparency. I mean,
and transparency for sure. But I'm just giving the attitude. Transparency is of course key as well and deals with data. And I'll say a word about this. I'll give a counterexample. In Bnei Brak, when it was quarantined, I know for a fact because I looked into it. There were violations of the quarantine in Bnei Brak, but the military did not enforce this. The military used to stop people and say, "What do you need? Can we provide you with what you need? Please go home. You need to go home. Let us know what you need. We'll bring it to you." So that was the complete different approach in Bnei Brak, and for the people in Bnei Brak said, "Oh, we were wronged by the decision to quarantine us, but we see now the Israeli military, all of a sudden helping us. That's an odd thing for us, and they really helped. They didn't try to just enforce the restrictive bylaws on us." The point you raised with respect to transparency is key. We have a huge issue with respect to transparency, and there might be litigation on that coming down the line, and we'll see how the court performs when issues of transparency are litigated. Part of, again, there is some obfuscation here because when the court blocked further access to the measures or the tools used by the General Security Services, the court did not say you have to erase all the data you already accumulated. So there is data out there. So what is the data? Why don't we have access to this? Can we check what uses were made of that data? That, you know, that's a trickier case. But at least the court stopped. So the court did the right thing, but it was easier for the court because the bulk of the need for the measures was has already occurred, because we're talking about now toward the end of the first wave of the pandemic.
Thank you, Deborah. Itamar, please. Itamar Mann. Unmute yourself, Itamar. No, we can't hear you yet. No. Itamar, we still can't hear you.
Can you hear me now?
Yes.
Yeah. Okay. Thank you. Sorry for that. Thank you for the very important conversation. I have two fairly, a quick comment and then a fairly straightforward question. The comment is that I'm not sure at all that Gadi is correct in saying that the issue of COVID-19 has not been securitized or framed as an issue of national security. I haven't had a chance to really look at a decision very closely and one eye through this conversation. I remember the conversation in the courtroom with Danya Kir and with Hassan Jabarin. It seemed like they were they were insisting pretty straightforwardly that this is indeed a national security issue. And I don't know if they wrote it down in the decision yet or in that way, but I would not at all rule out the idea that it will become a national security issue either now or in the very foreseeable future, and that the court will accept that. I think that it goes, if I understand correctly, I do think that it goes hand in glove with previous jurisprudence from our court. During the arguments, I was thinking specifically about the whole discussion of national security as it appeared in the issue of gas drilling in the Mediterranean Sea, where it was also accepted for the purposes of a statute concerning antitrust law, that it is a national security issue. So I would like to hear your position on not only on what it means, if it will become a national security issue, and should it become a national security issue in your view?
So Itamar, I heard the first part of your question. You were breaking up during your second part. So with respect to the national security dimension, I also think that it is easier for the state to convert the matter into a national security matter, and you're right that the state has done so with respect to matters concerning the Mediterranean. It did have some sway with the court, although the court ended up not writing a decision that is based on national security primarily, but it was important for the state to present it as a matter of national security and to do the framing. I fear, however, I hope, rather than use fear, let's use hope. I hope that the court will see through that move by realizing that if you conceptualize this as a national security matter, then the potential enemies are us. And that's a very dangerous move towards potential distancing from the underlying premise of liberal democracy. So I think, again, as a matter of perception, the idea is if you could say there's a national security, but the virus is a threat and stop there, and then use the notion that we have to protect ourselves against a virus as we would have to protect ourselves against aliens, should aliens ever invade our blue marble, then that's fine. But as soon as you go the extra step and say then there's a risk that you assist the enemy if you do not strictly obey the rules issued by the state against this enemy, and therefore you should be treated as if you're assisting the enemy. This is betrayal. And then the law is pointed at us, and I think that's a very dangerous move. It changes our consciousness, our legal consciousness, and I think we should. Therefore, I think we should resist this. If we can stop it by saying, securitization stops at the inanimate things, whatever viruses are, maybe they're alive, but they're not human. So fine, but I fear that it's a dangerous concept to play with. And again, I think that the work of Deborah and Saskin, the idea of how you build resilience and solidarity, you do this by having a common goal, a shared goal. So there has to be that which you fight for. I'm not sure that you have to insist on that which you fight against and demonize the virus or something like that in order to generate the perception of what you're doing. But again, it remains to be seen. I fear then, and again, maybe your second part of the question had to do with the potential shift to a surveillance society. I think you were asking about that. Again, you were breaking up. If this was your question, I think that this is why it's part of our constitutional moment. I do think that there is a potential shift. There's a path. We're at crossroads, and then the path leading to a highly monitored society whereby we monitor ourselves all the time. The state monitors us and the market monitors us. There's value not only in monitoring us to run algorithms that will predict what we buy, which is the logic of the current surveillance capitalism, as Shoshana Zuboff wrote in a famous book. But now there may be an extra layer, a very fundamental layer of we need to monitor us for survival. Now, when you say you need to monitor, we need to monitor ourselves using the state, using the market, and using ourselves as individuals, potentially even by scores, then that's a huge shift away. That's a path that leads away from liberalism. We will emerge as a non-liberal democracy to the extent it will even be a democracy, and I fear that. And again, the South Korean example is fascinating. So in South Korea, it's a democracy. They authorized full surveillance. All avenues of surveillance, cell phones, credit cards, cameras, all surveillance methods. So I think that to the extent that we emerge on the other side of this with that, and I think we will to an extent, simply because until we have a vaccination that will be part of our protection technique, we have to be very wary. We have to, all of us, have to care way more about privacy, including Ellie, by the way, Ellie usually doesn't care about privacy so much, to the extent that, to the extent some conditions are met, some conditions set by Ellie are met with respect to bias and that kind of stuff. But I think we should care here precisely because of the other point Ellie made, and this is the potential for illicit goals, illicit purposes. And even if they're not illicit now, it will be too tempting. The potential for social control is just too tempting. You will tell yourself, or the state will tell itself that it's doing something good for us. But we see how easy it is to then design campaigns to influence us this way or that way. And then the whole notion of social control really, I think, becomes salient. So I think we should really insist, including through judicial review, that whatever monitoring tools we use are truly voluntary. and the state cannot keep records on us, or the corporations cannot keep records on us. So we should be really vigilant. If we should care about anything now, is again this notion of access to data, transparency, access to data, and then control over our data. I think that's key if we care about the underlying fabric upon which other layers will be built in the future. But I could be wrong about that. This is just my assessment.
Thank you very much, Amnon and Itamar. It's interesting, you opened a totally new door, which will not get into it, privacy. And actually now we see this as a real dilemma. You know, countries which gave up privacy gave much more freedom and liberty of movement to their citizens. So the balance, you know, either you give up your privacy or you give your freedom of movement, but this is a very different debate. It's also interesting that in the exchange between you and Itamar, both of you actually referred to national security in a very limited sense, in the intuitive meaning that we were using until now, that, you know, national security is security as a cause of wars, terrorism. But we, you know, national security is also the security, health security of everyone, or the economic security. So actually, maybe we have an opportunity here to change the Israeli discourse that national security is only on one singular background. And maybe this can be a positive development. Amnon, thank you very much for talking to us about judicial review. You know that you said yourself, judicial review will become in the next few weeks a crucial factor in our life. You know, we didn't ask you what you predict will happen. You said yourself that the new coalition agreement involves changing basic law, the government, changing the checks and balances. Actually, in a sense, what it is meant to achieve, less corruption and securization of our democratic institution, it might achieve exactly the opposite. And a very key question is how the court will react, to the petition against the appointment of Netanyahu as prime minister, how the court will react to all these during emergency constitutional amendments that enable the executive more power, whether the court will go with the majority or the court will have its really, really formative moment. This is something that we'll see in the next few weeks. Thank you again, Amnon. We will convene again on the 30th of April, noon time, at 2 o'clock time this time. We will host Itai Epstein, who will talk about paramedic, humanitarian response and humanitarian right protection in the time of the Corona era. So thanks very much, Amnon, again. Thanks for all the participants. See you on Thursday, I believe.
See you. Thanks very much. Thanks, Amnon.
Thank you. Great to be here. Thank you.
Thank you.
Bye.
Bye.